honorable members of Parliament of Bhutan and delegates.
One second, sorry. I forgot to, while I introduced her to you, Professor Kalpana, I just wanted to mention just 2 words, that this whole team consists of parliamentarians, 4 of them.
It is the afternoon and the last session in a long day, so I hope that I can keep your interest in something that tends to be quite dry. I am really honored to be here and to have an opportunity to speak with you. I'm also particularly happy that I've been asked to come here by Dr. Suryanarayan Reddy, who I must, on an autobiographical note, say was my first teacher in sociology. Years ago, 25 years ago. And it was because he began to teach me sociology that I went on to do a PhD in sociology much later. But a favorite teacher calls and you come. But also what kind of attracted me here is the group itself and the rare occasion that a group like this presents to somebody like me. I actually wondered, because like Mr. Kupswamy, I got the tail end of what he said in his talk. And I wondered really for the past 2 days, I've been trying to see how to pitch this when you talk about constitutional bodies and standing committees to a group of parliamentarians. I read and I think about it. You act and you know about it. So in a sense, then, what I'm saying is already something that you're doing. And there is bound to be that gap. So please bear with that gap. And I will try to see how I can actually look at what we have in India. And maybe we can think about the structures that are in existence in Bhutan and the kind of structures that you might actually create as you go along, because you have a wonderful constitution. I was immersed in it for 2 days. For me, it has immense possibilities. So on that note, I will just next. Basically, when I look at the field of the Constitution, and that's really the one document that I have constantly worked with, and that is that the Constitution really embodies certain core values. It doesn't give us those core values, it affirms those values. The values are there in our societies. The values are there in our, thanks. The values are there in our collective spirit to a large extent. And through the medium of the Constitution, what we actually do is to affirm these values. Now, having affirmed the values through the enactment of the Constitution, we are still left with the challenge of ensuring that those values percolate from the Constitution into governance. So you have values enshrined in societies. These values are absorbed and enshrined in the Constitution. But how do you then translate these values from the Constitution into governance? And I think that process of infusing the spirit of the Constitution into governance is what creates the logic for constitutional bodies. And standing committees are, a part of constitutional bodies or a consequence of them. But the logic really comes from the spirit of the Constitution. In India, one of the architects of the Indian Constitution, Dr. B.R. Ambedkar, he was in fact a prime mover of the Constitution, used the term constitutional morality. And when I looked at the preamble of the Bhutanese Constitution, I felt that this would really make a lot of sense, because when he spoke about constitutional morality, what he said was that we are putting in place a moral order, but we are putting in place a just moral order that eliminates all that is negative and all that is wrong in our societies, replacing it with an ethic of justice and equity. And that for him was constitutional morality. And so I think that when I was looking at the whole pattern of constitution making and constitutional bodies, I felt that perhaps one of the reasons why we have constitutional bodies in place is to find a mechanism through which we can then put constitutional morality in place at every level, in every sphere. If you look at all the constitutional bodies that we have, there are some basic principles that seem to govern the establishment of these bodies. So they are not arbitrarily selected from the Constitution, but it is quite clear that in the Constitution, the elements that are then translated into formal structures, like constitutional bodies, are elements that will further the cause of equity, which is something that is a perennial concern, which will further the cause of justice. It will further the cause of transparency and accountability in governance. It will make equal opportunity a reality. There will be a regulation of both political and administrative procedure in interests of fairness and to eliminate arbitrariness of any kind. A major concern in constitutional law in India has been the elimination of arbitrariness. That is, that everything must conform to the logic and spirit of the Constitution, and everything must conform to the procedure that realizes that logic and spirit. Anything that does not conform to the spirit of the Constitution or the procedure that is laid out is deemed to be arbitrary. And finally, the value of non-discrimination. So there is, of course, equity, but there's also non-discrimination. And non-discrimination is basically the curtailment of any negative conduct. So with reference to women, with reference to ethnic minorities, with reference to poor people, with reference to, in India, castes that are at the bottom of the social order, there cannot be any form of discrimination practiced against them, if one looked at the framework of the Constitution. And of course, we have very differing contexts. And for me, these differing contexts between India and Bhutan are evident in the framing of the Constitution itself. And I have here, and you of course know it very well, two small excerpts from the Bhutanese Constitution. And what strikes me with these excerpts is that you have a focus on happiness and well-being. But it's not just well-being. If you look at the Indian Constitution, you will have a focus on unity, you will have a focus on diversity, you will have a focus on justice, peace, secularism, and well-being. But you don't have a focus on happiness. And this is really what kind of sets the Bhutanese Constitution quite distinctively apart from the Indian Constitution. And I will come back to this later, but I think that it will be a very interesting exercise to see how one would actually map and measure gross national happiness through a standing committee or a constitutional body that takes in changes in the definition of happiness or its indices from time to time. The other two major points in the Bhutanese Constitution that I found were quite distinctive from what I see in the Indian Constitution is the concern with culture. And what strikes me with the concern with culture, in India, in public debate, very often when we speak about culture, we speak about culture as this unique, timeless entity that is linked to tradition. And we are constantly then asking precisely for this. As people who are engaged in constitutional deliberations, we are asking precisely that culture should be considered as an evolving force, that you should see culture as something that is continually evolving and as something that must change in relation to and be sustainable in a progressive society. So when I actually saw this, I said, okay, but this is what we are asking for, and this is what is already there. So for me, that was another point of that set it apart. And also the concern with the environment, which is in a whole article that focuses precisely, I mean, just on the environment, even before you focus on individual rights. If I'm not mistaken, the environment chapter comes before fundamental rights. And I think that what I find really interesting is the focus on the collective social good as being prior to the individual social good, and therefore the individual good arising out of the collective good. And the reason why I flagged these parts of the Bhutanese constitution is because these, for me, are the areas that point to a way of looking at constitutional administration very differently in Bhutan, and possibly, of Bhutan actually setting a measure for most other countries to go that way. And if I were to come directly to what I'm supposed to be looking at, when I did a quick reading of the Bhutanese constitution, I found that there were constitutional bodies that are already in place. The constitutional bodies that are already in place are the Judicial Commission, the Election Commission, the Civil Service Commission, the Anti-Corruption Commission, and the Pay Commission. I may have missed some, but of these, the Election Commission, the Civil Service Commission, which in Bhutan is the Royal Civil Service Commission, here it's the Union Public Service Commission. The Anti-Corruption Commission, it's not a constitutional body, it's more a statutory body here. It's created by statute. We have the Central Vigilance Commission, which is a little different from the Anti-Corruption Commission. And we are still now in a heated debate after, I don't know if you have followed Anna Hazare's movement, but after Anna Hazare's movement, we are in a heated debate on whether we should have an anti-corruption commission, what should be the structure of that commission, how should it be linked to the constitution, should it be a constitutional body, which means that you need a constitutional amendment, or should it be a statutory body, which means you just enact the Lokpal bill and then you have the body that arises from that. But it seems that you have sorted that out even at the inception stage by, making way for an anti-corruption commission, and not masking the term corruption in many words, but being quite direct and saying corruption. Here we tend to use vigilance, or we tend to use Lokpal and transparency, but to name corruption as corruption is really what is important. Yeah, and the Pay Commission. These are then the bodies that have parallels in India. What is very striking for me is the National Judicial Commission. We have within the Constitution of India the entire structure of the courts, but the appellate courts basically, what are called the constitutional courts, that is the Supreme Court and the High Courts. We have the entire structure for the Supreme Court and the High Courts, including the procedure to be followed for the appointment of judges, set out quite clearly in the Constitution. But we don't have a judicial commission. Either at the national level, for none of the constitutional courts do you have a judicial commission. What you have is a judicial services body, like the Public Service Commission, where you have appointments to the magistracy and the courts of original jurisdiction, the criminal courts, the civil courts, the labor courts, all courts that don't directly deal in constitutional matters. All the trial courts are governed by the judicial services, which is exactly like the Public Service Commission. Officers who have graduated in law go through an exam, they are ranked, and according to order of merit, they are offered appointment, and that is a form of public employment. But as part of the anti-corruption discussions, consequent on Anna Hazare, and in fact even before Anna Hazare, the whole movement that Aruna Roy, for instance, set off, we've had a long discussion on the need for a national judicial commission. This obviously cannot be a constitutional body. It will have to be a statutory body, unless we bring about an amendment in the Constitution. The only way in which you can actually remove a judge of the High Court or the Supreme Court is through an elaborate process of impeachment. And it is not that we have not had concerns of corruption in the judiciary, but we've had at least 2 instances that I know in the last 15 years where the bar has almost succeeded in getting the requisite number of parliamentarians to support an impeachment motion, and then when the voting, it has come to the floor of the House, it has fallen. Despite the fact that the parliamentarians in a majority accepted that this judge deserved to go, and there was overwhelming evidence of his corruption at various levels. So given that, and given the fact that there can be there is no other procedure. For instance, if a judge is found to have not recused himself when a case in which he has an interest appears in his court, and that has happened too, there is no procedure that you can adopt even to nullify that decision. So conflict of interest remains a major concern that continues. Because of these 2 issues, conflict of interest and corruption, there has been a demand that when you have the Lokpal, or the anti-corruption body in India, that the judiciary should be brought within the purview of the Lokpal. And the Supreme Court has actually opposed it quite strongly. The discussion then veered to whether we need to have a separate structure like this, where anti-corruption would be for all government officers across the board, and the Judicial Commission should take care of any charges of appointments and dismissals of judges in the appellate courts. And in India, you will find the numbers in brackets are the articles in the Constitution whereby these commissions are constituted. In India, there are 2 levels of bodies that we can actually find. These, in the first slide, are all constitutional bodies. All of them are set up through an article in the Indian Constitution. The Finance Commission, the Public Service Commission, both at the union, at the center and the state levels. Tribunals also, administrative tribunals notably at the union and the state levels. The National Commission for Scheduled Castes. Earlier, this was the National Commission for Scheduled Castes and Tribes. Subsequently, it was bifurcated, and you have a new article being introduced. So you have a National Commission for Scheduled Castes and a National Commission for Scheduled Tribes. You have the Official Languages Commission. The trouble with India is that you have languages and dialects that run into more than you can count. Official languages, but also the dialects in each language are very, very large in number. And within that, the problem has been on what should be the link language. Because in terms of official communication, although Hindi is the national language, there are states in which Hindi is not understood at all. Tamil Nadu, parts of Kerala, parts of Karnataka, even parts of interior Andhra Pradesh, Hindi is simply not understood. So what then will be the link language? Tamil Nadu, in fact, voted for English to be the link language. And then there was this whole debate on English being the language of the colonial rulers. So why would you want that as the link language? But the point then was that English was more accessible to people in different states, so that you have 2 link languages. You have English and Hindi as the link languages. And in states where you don't have Hindi spoken, the state language, because we have had a reorganization of states on linguistic grounds, so every state has a distinct language, except the Hindi belt. the state language also becomes the third official language within the state. And then, like Bhutan, you have the Election Commission. To just dwell on the constitutional bodies for a little bit, you will find that some of them are regulatory and governance-oriented bodies, particularly the Finance Commission, the Public Service Commission, the tribunals, the Official Languages Commission, and the Election Commission. These are all related to procedure, governance, and the regulation of public life. The National Commission for Scheduled Castes and the National Commission for Scheduled Tribes are both commissions. Yeah. You know, I'm actually not used to PowerPoint. The National Commission for Scheduled Castes and the National Commission for Scheduled Tribes, these two are in fact commissions that are focused on the principle of equity and non-discrimination. Because within India, you find that there has historically been a very marginalized status that scheduled castes have enjoyed. Historically, they have been at a disadvantage both in terms of education and public employment. And scheduled tribes have had a similar problem. Educational attainment is very low. Public employment figures are very low. Levels of isolation from the mainstream are very high. And so you have the National Commission. I did something. The red button. Yeah. So you have the National Commission for Scheduled Tribes actually, focusing on specifically targeted questions of the betterment of the scheduled castes and scheduled tribes. They're also a body that receives complaints, that processes complaints of collective discrimination. So if, for instance, scheduled castes and scheduled tribes complain that there has been a collective marginalization of them in any state, or that they have not been able to access equal opportunity, then the National Commissions for Scheduled Castes and Scheduled Tribes would go into that problem and investigate it in some detail.
Please tell us something about
The
the tribunals.
tribunals are also constituted under the Constitution, but they are basically bodies that are formed to regulate administration. So if there are disputes with relation to administration, whether it's in relation to labor or service or arbitrary action, these can come up before the administrative tribunals. And these tribunals are constituted both at the central and the state level. So similarly also with the Public Service Commission. With the regulatory bodies, what you find is that particularly the Public Service Commission and the tribunals, and the two are linked, which is why in the Constitution they come immediately after, one immediately after the other, because the tribunals regulate the conduct of the Public Service Commission officers, and they're immediately applicable to them. The Central Vigilance Commission also is immediately relevant to those two, to those bodies. So basically, these are regulatory bodies, and they are regulatory bodies for governance and administration, yeah, for public service officials, not for political appointments. Now, apart from the constitutional bodies that actually take care of constitutional matters, we also have another level of bodies that are based on statute, but that also draw their logic from the Constitution. In the early 1990s, there was a huge agitation for reservations and identification of the backward classes and affirmative action for the backward classes. And there was a judgment that immediately followed, called the Mandal Commission judgment, that actually said that you must provide for affirmative action for classes of people who have known to be at a historical disadvantage. And consequent on the Mandal Commission judgment, which was a constitutional case, you had the formation of the National Commission for Backward Classes. Now, this is a constitutional matter. It is something that comes within the purview of Article 16 of the Indian Constitution. Article 16 of the Indian Constitution looks at equality of opportunity. Equality of opportunity, particularly in matters of education and public employment. And by public employment, I mean government employment. And in a constitutional matter, consequent on that litigation, you have the National Commission for Backward Classes coming up through the enactment of the National Commission of Backward Classes Act 1993. And this then is a procedure that one might follow. Effecting a constitutional amendment each time might be quite a tedious process because you have to go into Parliament, table the bill, vote on the bill, and it's something that can sometimes take years. So it's become more and more difficult to amend the Constitution after a series of judgments in the Supreme Court. So what is now being increasingly resorted to is to simply have an enactment, to have the tabling of an independent bill in Parliament, setting up a particular commission. And that is what you find in most of the recent cases. So the National Commission for Backward Classes is not a constitutional body, it's a statutory body. And there is a huge overlap between the work that the National Commission for Backward Classes does and the work that the National Commission for Scheduled Castes and Scheduled Tribes do, because all of them look at social backwardness of different classes of people. Apart from the National Commission for Backward Classes, there are a whole set of statutory bodies that again draw from the Constitution. In the Indian Constitution, Article 21 speaks of the right to life and personal liberty. No person shall be deprived of his right to life and personal liberty except according to procedure established by law. It's a little different from the Bhutanese Constitution where you have adopted the due process clause. In the Indian Constitution, it is according to procedure established by law. And the National Human Rights Commission is something that draws the reason for its existence directly from Article 21 of the Indian Constitution. Again, this is a statutory commission that came into being through the enactment of the Protection of Human Rights Act 1993. Now, although it is called the National Human Rights Commission, you will find that this commission, in fact, deals with a whole range of violations. So it deals with cases of discrimination and violation against scheduled castes. It deals with violations against scheduled tribes. Increasingly, you have persons with disabilities coming up for major concern. And persons with disabilities, in fact, possibly barring the South African Constitution, they have not found their way into any constitution. I was actually looking very interestedly at the Bhutanese Constitution to see if they figure there, but I was a little disappointed that they didn't figure there. But the South African Constitution is possibly the only constitution in the world that specifically mentions disability in its equality clause, Article 9. But persons with disabilities actually come to the National Human Rights Commission, and there are several orders that the National Human Rights Commission passes. But also a bulk of cases that come before the National Human Rights Commission have to do with arbitrary arrest and detention. The lack of due process by police and police jail authorities and army authorities. Although much less with army authorities because there is the whole question of immunity of the armed forces that comes in, much more with police and jail authorities. The most recent statutory commission that we have set up here in India is the National Commission for the Protection of Child Rights. Again, you will find a lot of parallels between the Bhutanese Constitution and the work of this particular commission, because you do have quite a heavy focus on the rights of the child. And in the Indian Constitution, you don't actually have a specific focus on the child except in the directive principles of state policy. Otherwise, the child, women, everybody broadly comes under the definition of person and citizen. So you don't have a specific targeted focus. But of course, increasingly, we know that children have special needs, that they have also special entitlements, which need to be addressed in very specific ways. And so we have the National Commission for the Protection of Child Rights that was set up again through an act, which was the Commission for the Protection of Child Rights Act 2005. But interestingly, with this particular statutory body, you had a constitutional amendment that came in immediately after, which is Article 21A. Immediately after the right to life article, you had 21A coming in, which is the right to education, that the state shall provide free and compulsory education for all children between 6 and 14 years. And if you look at the work of the National Commission for the Protection of Child Rights, you will find that there are two major areas of focus, and they are both related. Those two areas of focus are education and the elimination of child labor. And the way in which the Commission defines it is that if it says that any child below 14 years of age who is not in school is presumed to be child labor. So all children must be in school, otherwise it means that they are engaging in labor, and therefore the legal measures against prospective employers and parents will be set in motion. So the National Commission for Child Rights, although it's a statutory body, draws its logic backwards into the Constitution and has a very direct link.
Madam, the difference I think here is, here you go by age.
Yeah.
But in Bhutan, I think it's up to standard 10.
Yes.
Education is compulsory.
Yeah.
Because in the rural areas, we find that a person 19 years of age and he's in class 6 or something.
Yes, yes.
But to give them the opportunity
Yes.
to learn, so up to class 10, compulsory.
Yeah, and which is actually a very enabling provision. You know, I mean, here the age is a cutoff, and not just in Bhutan, in India as well, that is a problem, because where you have children going into school late, or children for reasons of economic and social conditions not being able to complete school in the exact time in which they are meant to complete school, they're out of the system. So there is a disadvantage there. And there has been considerable critique of the framing of this clause, because this clause is very recent. And so the discussion has been that it could have been wider. For instance, 0 to 6 is not included in this. But then 0 to 6, this is very specifically on the right to education. So 0 to 6 are not a cohort where they actually go to school, which means that we needed to have a clause just on the rights of the child, in which education might have been one clause, but you could have had other clauses as well, and that hasn't happened. You have, in India, as you all well know, the question of minorities, and minorities have received a very specific focus in the Constitution. But it was not until 1978 that a Minorities Commission was set up. The first time the Minorities Commission was set up was not as a statutory body, but it was as a body set up by the Ministry of Home Affairs, because there had been increasing tension between minorities and other communities. And so it was set up by the Ministry of Home Affairs, which is in charge of law and order. Subsequently, in 1992, we had the National Commission for Minorities Act, which brought into being the National Commission for Minorities, which again, like the Scheduled Castes and Scheduled Tribe Commission, looked at questions of minority status, conduct studies. All of these commissions are meant to conduct status studies, to point to the gaps in development, to point to urgent development and governance needs vis-a-vis these communities, and guide governmental action to enable them to join the mainstream. That's the basic purpose of all of the statutory commissions. You also have the National Commission for Women, which again is not a constitutional body. It is a statutory body formed by the National Commission for Women Act. And the purpose of this commission is self-evident. You have, if you look at the development indicators between men and women, you will find that women fall short on all development indicators, and there is a disparity based on gender. So the National Commission for Women tries to address that disparity through studies, through inquiries, and also through fact-finding where there have been cases of violence. So those were as far as the constitutional and the statutory bodies are concerned. Within the constitutional and the statutory bodies, you have a whole plethora of bodies that regulate the daily business of government. Vigilance commissions, water commissions, particular rivers. So there is not just the Central Water Commission, there are also commissions that go into river disputes and river sharing and all of that. So you have a number of commissions that look at the day-to-day regulation of the business of governance, governance at the central level, at the state level, and between state and center. Yeah, so I've not actually gone into each commission, but just broadly said that if you look at commissions, if you forget about the term constitutional bodies and you look at commissions, you will find that they're roughly of three types. The first is regulatory. The second is commissions that are focused on questions of rights, broadly human rights, but drawing from the Constitution. And the third are commissions, again, that are focused on rights, but draw from a statute. So those are the three broad classes that you will find within the bodies that we have. Apart from that, we have another set of instruments that are used very frequently, and these are called the parliamentary committees. In the parliamentary committees, and I can give you an example in a little while, in the parliamentary committees, you have ad hoc committees which may be constituted for a very clearly defined purpose. So if, for instance, you want to know, you want to have details about education among the disabled in a particular time period, you will constitute an ad hoc committee that will then furnish the parliament with the necessary information within a given time frame. And the ad hoc committee then ceases to be in existence once that report is tabled. You have standing committees. The standing committees are basically committees that set out the rules and regulate the business of parliament. And so this is, you have standing committees on privileges, you have standing committees on rules, you have standing committees that monitor different aspects of parliamentary life, because as you live through it, and I don't, you know that it's behind the sessions that happen in parliament. There is so much of work that needs to go on in order for those sessions to happen, and the standing committees basically ensure that that happens. What is really significant, however, is the plethora of joint and selective commissions, committees that are constituted by Parliament. Now, with this, what happens is that where, for instance, a subordinate legislation is being proposed, suppose you have a bill that's being tabled before Parliament, and you want a wider feedback on that bill than the number of members of the Parliament. So you have 200 members in Parliament, you want a wider feedback on a particular bill. Then you can actually have a joint committee, that is a committee that consists of members of both houses, or a select committee, and invite public opinion from notable people who are knowledgeable about the affairs that that particular legislation pertains to. So having gathered that expert opinion, you can then, as a joint or select committee, place that information before Parliament so that the Parliament can take an enlightened view of the matter that is pending before it. And one of the committees that actually did some really path-breaking work in India on gathering opinion and putting it before the Parliament and actually coming out with a very good legislation is the Committee on the Domestic Violence Prevention Bill, where they had extensive hearings that spread out over almost 1 year. And subsequent to that, we have one of the most enabling domestic violence prevention legislations in the country that also works very well. And you could, of course, have that for a range of things. We have the Forest Rights Act. With the Forest Rights Act as well, we had a whole series of consultations and parliamentary committees that were involved in the consultations. So where the parliament needs to consult with civil society, or where the parliament needs to consult with extra parliamentary expert opinion, then you use the format of the joint and select committees that can then call for opinions from outside. Yeah, and even within the parliamentary committees, I was trying to look for a link between the parliamentary committees and the constitutional bodies. And the link that I found was in these two. There are two parliamentary committees that are called the Committee on Welfare of Scheduled Castes and the Committee on the Empowerment of Women. Now, the Committee on the Welfare of the Scheduled Castes consists primarily of parliamentarians from scheduled castes who assess the difficulties that scheduled castes go through and table it before the parliament. So you can have within parliament specific interests represented through the work of committees that parliamentarians then form. Yeah. So basically then what, what I had kind of planned to highlight is the fact that while you have a basic structure of how one can actually link the Constitution to governance, the exact links that you make. So do you link, for instance, and I go back to the question I started with, do you link an instrumentality of a commission to the idea of gross national happiness? Or do you link an instrumentality to the question of equal opportunity? Equal opportunity in India, for instance, we don't have an equal opportunity commission. But this was about 4 years ago. There was a discussion, and that was the expert group that I was part of, where the Minority Affairs Ministry felt that it was necessary to actually have, apart from the Constitution, to have a commission that looks at equality of opportunity, that is targeted specifically at that across all categories of people, and equality particularly in two fields, in education and employment. And as a result of that effort by the Minority Affairs Ministry, we had actually drafted an equal opportunities bill, and I was part of the drafting committee. So we had a comprehensive draft of the Equal Opportunities Bill, which we have then submitted to government. But 4 years down the line, the government has not actually had the time to deliberate on the bill. So it's still under consideration. So I think that the process of legislative drafting is also linked to the formation of constitutional bodies, because a lot of the legislations that we are talking about need to be operationalized through an institutional mechanism. And so what will the structure of the body be, and what are the redressal mechanisms we can build into it? These are really questions that we need to think through. Thank you. I'm done.